So a federal judge in Texas just struck down the ATF's new rule on frames and receivers. So let's talk about this. But real quick before we jump into this video, if you agree that the ATF needs to be abolished, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. So like I said in the intro, in this video, we're going to be talking about a case coming out of the state of Texas. And in this case, a federal judge just struck down the ATF's new rule on frames and receivers and granted an injunction in favor of the plaintiffs. Now, there are some interesting things that came out of this case, and this has huge implications for the implementation of the ATF's new rule on frames and receivers. There are multiple cases right now that are going on against the ATF and this new rule on frames and receivers. And this is the first one where we see a federal judge, a federal court, actually granting an injunction against the enforcement of this new rule. The case we're going to be talking about in this video is Vanderstock v. Garland. This is a lawsuit led by Firearms Policy Coalition, and it's against the ATF and their new rule on frames and receivers. This case was filed in the Northern District of Texas and was just ruled on by a district court judge, Judge Reed O'Connor. Now, if you're not aware of what this lawsuit entails and what's going on with this whole ATF new rule on frames and receivers, let me explain real quick. This new rule by the ATF is essentially a restriction on the sale of 80% kits. Under this new rule, 80% kits are treated to actually be firearms. This new rule went into the regulatory definition of a firearm and changed the definition through a web of references so that 80% kits are actually defined to be actual firearms. Since 80% kits are considered to actually be within that definition of a firearm, they are now subject to serialization requirements and background checks as well. So that is a general rundown of what this new rule on frames and receivers did. In this case, Vanderstock, the plaintiffs requested a preliminary injunction from the court and essentially sought the court to enjoin, i.e. halt the enforcement of this new rule on frames and receivers. However, for a preliminary injunction to be granted, the plaintiffs must show first, a substantial likelihood of success on the merits, 2, a substantial threat of irreparable harm, 3, that the balance of hardships weighs in their favor, and 4, that the issuance of the preliminary injunction would not disserve the public's interest. So those are the standards that the court considered, and on review, the judge in this case found in favor of the plaintiffs, found that they carried the burden, and therefore granted them a preliminary injunction. Now, it was a little bit isolated in its enforcement mechanism. It's only in favor of one of the plaintiffs, which is Tactical Machining. So we're going to get into that a little bit later, talk about kind of the broader implications of this, but it was a good win because you had a judge essentially saying that what the ATF was doing in this new rule on frames and receivers is in fact invalid. Now, in reaching his decision, the judge said some very important things. He stated, Congress carefully defined its terms in the Gun Control Act. The primary definition of firearm in the Act contains 3 parts. Any weapon, including a starter gun, which will or is designed to or may readily be converted to expel a projectile by the action of an explosive. So there the judge is pointing to the actual definition of a firearm under the Gun Control Act. He went on to state, under this primary definition, a firearm is first and foremost a weapon. Underscoring that point, Congress explicitly named starter guns in the definition because a starter gun are not actually obviously a weapon. Then because weapon parts are also not weapons, Congress created a secondary definition covering specific weapon parts, the frame or receiver of any such weapon. Congress did not cover all weapons parts, only frames and receivers, and only the frames and receivers of any such weapon that Congress described is the primary definition. But the final rule did not merely update ATF's terminology. ATF added an entirely new section expanding its jurisdiction to include partially complete, disassembled, or non-functional frames or receivers. ATF now claims authority to regulate parts that are designed to or may readily be completed, assembled, restored, or otherwise converted to function as a frame or receiver. He stated that which may become a receiver is not itself a receiver. Congress could have included firearms parts that may be readily converted to frames or receivers, as it did with weapons that may readily be converted to fire a projectile, but it omitted that language when talking about frames or receivers. The judge then states, ATF's new definition of frame or receiver is facially unlawful. The issue here, he states, is whether the ATF may still regulate a component as a frame or receiver, even after ATF determines that the component in question is not a frame or receiver at the time of evaluation. Congress has not extended ATF's authority so far. That the firearm part is designed to be or may one day become a frame or receiver does not change the fact that in that moment, it is not a frame or receiver of any such weapon. This judge found that the new rule is facially invalid since it regulates parts that may become frames or receivers one day, but are not those items in their current state. Congress only gave authority to regulate actual functioning frames or receivers. To go beyond that authority is invalid. Then this judge goes on to also state that a weapons part kit is also not a firearm, and therefore the ATF's new rule which regulates those firearms parts is also invalid. The judge states ATF has no general authority to regulate weapons parts, but the final rule grants ATF that general authority by copying language used throughout the statutory definition. It takes phrases like designed to and may readily be converted and assembled from various places in the statute, cobbling them together to form ATF's own definition of firearm. Those terms may add a patina of credibility to the drafting, but they tarnish Congress's carefully crafted definition. More importantly, they unlawfully expand ATF's authority beyond the boundaries set by the Gun Control Act. The Gun Control Act's precise wording demands precise application, he said. So there in that section, you have this judge calling out the ATF on their own twisting of the language in the statute to try to get some sort of language to regulate parts and parts kits. The judge points to the fact that Congress could have expressly included such language into the definition if it wanted to. It was aware of that language. It was aware that the inclusion of that language could have helped regulate parts and parts kits, but they decided not to, and that's important. Therefore, he ruled that tactical machining has shown that it is entitled to a preliminary injunction. However, he found that the remaining plaintiffs have not carried the same burden. Plaintiffs also have not shown that a nationwide injunctive relief is appropriate at this stage, he stated. He also went on to state that covered by the injunction, tactical machining can operate its business as it has, free from the threat of enforcement of the final rule's unlawful redefinitions. Presumably, tactical machining's customers are still subject to felony charges for buying its products, and it may be the case that tactical machining's business will fail unless the injunction is substantially amended to cover a substantial portion of tactical machining's customer base. But for now, plaintiffs offer neither evidence nor argument on that point. So here is an important nuance to this injunction and the granting of the injunction. The injunction was granted against the ATF from stopping tactical machining from manufacturing and selling these parts kits, these incomplete frames and receivers, these 80%er kits. The injunction was specific to this one manufacturer against the ATF and their enforcement of that new rule on frames and receivers. However, the injunction does not protect the customers who purchase those items, and the judge even stated expressly in the order that the customers are still likely subject to felony charges if they purchase those items. He did state that the injunction may need to be amended in the future to also protect those customers who purchase those items, but right now at the time he has not extended the injunction to customers as well, and he is also offering it an opportunity for some supplemental briefs and some supplemental evidence to be submitted to try to expand the coverage and scope of the injunction that he's granting. So this is still an important win even though it's limited to just one manufacturer. This is one of the first times that we've seen a judge find that the ATF's arbitrary expansion of definitions through new rules is actually invalid. So solid win. Thank you to FBC for fighting this battle and getting this win. If you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, like this video and like support the channel. One of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algore's rhythm. It adds fuel to his jet and signal to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, helping me to reach and educate more people than I could ever do on my own. So again, thank you so much for all of your support. And as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this is built by armed scholars, and this nation will be maintained by armed scholars.